Welcome to the Dmitchik Law Firm YouTube channel.
In light of the election's results, we can expect drastic changes to immigration enforcement. These changes will impact not just immigration matters, but also criminal proceedings. This is why I want to talk to my colleague Michael Walsh, a criminal defense attorney, and get his recollections of President Trump's previous term. Michael Walsh, as I mentioned, is a criminal defense lawyer with over 40 years of experience in the field. The primary jurisdiction where he practices is Illinois, but he also works on cases in California, New York, Massachusetts, Oregon, and a number of other states. I am an attorney with over 10 years of legal experience. For the first 7 years, I practiced immigration law, after which I transitioned to criminal defense as well. Both Michael and I actively practiced law during President Trump's previous term, 2017 through 2020. Today, we want to discuss specifically ICE detainers. For those who don't know, ICE detainers are requests by Immigration and Customs Enforcement to law enforcement agencies to continue detaining an individual for up to 48 hours after this person has been scheduled to be released from custody. So, Michael, in your criminal defense practice during the previous term of President Trump in 2017 through early 2021, how have you seen ICE detainers play out in criminal cases?
Well, one of the problems we have when we have a criminal case is if the person has a detainer on them, is that bail becomes problematic. If the person makes bail and ICE has filed a detainer, then all that effort getting bond set and the family all prepared to comply with the bond package, it now is for naught, as ICE will then come and grab a hold of someone and ship them to another facility. It's always better for the defense lawyer to have access to his or her client. But when you get detained, you are now at some other location, like for example in Illinois, in the Chicago area, there is an ICE facility in Broadview, which is somewhat convenient, but on most occasions, they contract with out-of-county detention facilities, which could be 2, 3, 4-hour drives away. So it impacts just initially on the client making bail, and then when the person gets shipped to another location, it makes for real problems to be able to communicate and meet with your client regularly.
Have you ever seen when the client would get shipped out of state?
Yes and no. If you're on the border of some of the states, like in Illinois, occasionally they might get shipped up to over to Muscatine, Iowa, where there's a lockup there that the federal government has a contract with, sometimes just above the Wisconsin border. There'll be facilities up there, Waukesha or Waukesha, or sometimes Madison if they really are shipping them a long way. But it can be very problematic for defense lawyers and for the family to be with and help their client or their family member going through what is a very difficult time.
And when it comes to the actual court appearances, have you seen any impact of the client being detained by ICE in the ICE facility on getting to court hearings?
Anytime the U.S. Marshal is involved, there's a problem. They never want to bring them to court. They don't want to be bothered having to send a car or a truck to pick some up. Manpower shortage on site, time away from that facility, more times than not, at least in the Chicago area, which is as big a area of a city and large criminal justice system, they just don't show up. And candidly, we've got to a point where we don't expect to see them.
And so what would be your suggestion if in this type of cases where there may be an ICE detainer and there's a bail, how would you suggest the family proceeds?
Well, if there's an ICE detainer, then you should probably now start talking to immigration counsel so that that attorney can now deal with the immigration court and try to convince an immigration judge or the immigration authorities that the client is not a risk to flee, to take off, to go somewhere. Now, that being said, you're more likely to succeed in a location that is more immigrant friendly, like Illinois is, especially around Chicago, because it's a city that does not wish to be detaining immigrants. That could differ if you went to downstate Indiana, where that's a very conservative area and much different than the Chicago area.
And it would probably also depend on the type of charges. Right?
Yes, the more severe the charges, the less likely you're going to get an immigration judge or the immigration authorities to agree to a bail just because of the issue of flight.
Right. Have you ever seen, let's say, court witnesses not showing up to court for fear of being detained?
I've had a couple of situations where I've had witnesses say, do I really need to come to court? And when you try to figure out why it is they don't want to come, you learn that they may have an immigration problem, that their green card has lapsed, they really have no status. During the present administration, that was less likely. But for example, about 5 years ago, I had a client who was from Lithuania. They were looking for him because he already had an order of removal. And as we walked out of the courtroom from his DUI case, two law enforcement officers were there waiting for him, took him into custody, and within 2 weeks, he was gone from the U.S.
Did that impact the case any further? Did this person need to testify later, or that was pretty much
it ended up getting resolved so that that person's testimony was not necessary, but it could have been problematic if we needed that person's testimony.
Definitely. When it comes to plea deals that you would see back in 2017 through 2020, did you see any change depending on whether the person was likely to be deported afterwards or not, compared to the next administration?
Well, we found during the prior administration, before the present one, that we could actually use the deportation issue to our benefit to suggest that does it matter if it's 2 years or 4 years, the person is going to be removed as soon as he's released from custody into parole, and then he will be taken by ICE and be subject to deportation. And we would always kind of suggest and to the prosecutors that you're going to hold him for 2 years here, and then he's going to get held for some time in ICE detention so that you're going to get the same time, and ultimately the person is going to be removed from the U.S., and that seems to be a satisfactory result, don't you think? And most prosecutors in a large urban area are going to kind of go along with that just so they can resolve a case.
And so, did you see ICE detainers applied and cooperated with differently in different states or maybe different areas of the same state?
Well, yes and no. Illinois is a fairly, and I'll use this term, liberal state compared to Missouri or Indiana, which borders on the southwest border with Missouri and the entire length of the eastern border with Indiana. We find just completely different views of things, completely different attitudes toward ICE and ICE detainers. Honestly, they're happy with ICE detainers just because they get to lock people up.
I see. So what would be your advice to someone who thinks they might be in trouble with the law and who are not U.S. citizens?
Well, if you're not a U.S. citizen and there's an issue that you may be aware of that could affect your freedom, number one, you need to get an excellent lawyer hired to represent you, both in your criminal case that may be upcoming, and more importantly, for your future, a good immigration counsel who can work hand in hand with your criminal attorney to try to arrive at the best result possible for your case. And I think lastly, that many lawyers forget about, and especially prosecutors, is that the U.S. Supreme Court has said in the Padilla case that lawyers have an obligation to understand what immigration consequences there are for any individual on a criminal case. and they put the onus on the lawyers, whether it's prosecutor or the defense lawyer, to do what is best for the individual that won't affect adversely that person's immigration status and the consequences of those immigration problems.
Definitely. And I also keep in mind that one thing to remember is that even despite the lawyer's best efforts, we never know what's going to happen to the immigration laws, because unlike criminal laws, immigration laws are retroactive, and we've already seen times when immigration laws have been made stricter. So something that could be a good result in the current legal landscape may not be such a great result maybe 10 years down the road if the laws are changed and certain things are now treated harsher than they used to be. So I think it's always important to remember to strive for the very best result possible, even if the current offer seems okay under the current laws. Michael, thank you so much.
You're welcome.
Now, much of legal framework remains the same, but it's important to remember that enforcement nuances can be different starting January, and they can also change throughout the administration. It's also important to keep in mind that nothing we say today is legal advice. If you need recommendations regarding your specific situation, please consult an attorney.